James Payne here again. Been creating an opportunity for freedom for over 40 years. We're talking about picking a jury selection. And so how do you pick a jury? Well, the phrase picking a jury is a little bit misleading because you don't get to go out and go ask people to come on and sit on your jury. They are brought into your courtroom by a court order. And so they are there, whether you like it or not. What you're really doing is educating the jury and getting rid of the ones who are the worst ones for your case. In a criminal defense case, as a criminal lawyer, the worst ones for your client, for your defendant. So today we're talking about the way that the lawyer gets off the worst ones, and it's called a strike or a challenge. Now there are two kinds, and today we'll talk about what is known as a peremptory challenge. There are challenges for cause, we'll talk about it in a different video, but the peremptory challenge is a challenge. It's a strike. You tell the judge, "Judge, we thank but excuse juror number 2. And you don't have to give a reason. That's the thing about a peremptory challenge. The lawyer, whether they're the prosecutor or the defense counsel, does not have to give a reason to the judge why they want that juror removed. There are a limited number of peremptory challenges. Take, for instance, the state of North Carolina. North Carolina has 6 and 6. The prosecutor has 6 challenges, peremptory challenges, and the defendant has 6 peremptory challenges. It's a little different in federal court. In federal court, the defendant has 10 peremptory challenges, and the prosecutor has 6. So how do you exercise a strike? Well, it takes experience. It takes knowing a certain feel for the juror who is either going to be favorable for the defendant or is already against the defendant, or be difficult to keep an open mind about holding the state to its burden of proof. How do you get there? Well, fortunately in the state of North Carolina, for instance, the lawyers get to ask questions of the jurors. So to get there, to get to that decision point, the lawyer gets to have a dialogue with the juror. That requires the lawyer having the experience and the know-how to talk to potential jurors about evidence, about the law, about who the juror really is, and get a good feel for that juror, a good feel for the energy, the vibe of that juror. And then the lawyer will reach over to his client, to the defendant, and they'll talk. And then they'll make a decision based upon everybody else they've talked to, whether they will exercise a strike on that juror or not. Don't even have to give a reason. Can be any reason. Can be kept quiet. The only restrictions on it are strikes based upon race or gender or some other constitutional protection. Otherwise, they're absolutely free and well used, are tremendous protection in criminal defense. If you have any questions, please don't hesitate to give us a call, 910-754-4389. Look forward to seeing you. Thank you.